This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As we do every single Wednesday, we are joined by Todd Lutsky from Cushing & Dolan to answer any of your questions in the estate planning realm. If you have a question for Todd, get our studio line a call at 888-205-2263. Again, that number for any of your estate planning questions for Todd Lutsky, 888-205-2263. Todd, thank you so much for joining us. How are you doing today?
I am never better. And you?
Doing great, minus all the snow that we've had. But
guess what? It's snowing again.
Yeah.
Just in case you want to know more.
It never stops. Question for you, estate planning and the grind never stops either. And one question I have is oftentimes I'll talk to clients about when is the appropriate time to consider doing trust work and what age is appropriate. And you can talk about that a little bit too. But another set of documents separate from the trust side of things are sort of your what you'd call the estate basic planning documents, living will, healthcare proxy, and power of attorney. Those documents, I often tell younger folks if they're getting married, that's something to consider right away. Do you have a general framework for the considerations on sort of those basic documents versus when you go up to that elevated, more sophisticated documents of putting a trust in place when you talk to clients?
Yeah, and I think that really does strike an accord with the guide we're giving away, which is back to the basics, because you got to understand the whole process, and it's not always for everybody. So let's just take an example. Start like you said there. Let's just say you're single, no kids, just starting out in life. Well, probably have a bank account, an investment account, and a new 401k.
Right.
I'm going to say this might be the only time you probably don't need a plan. I'm going to say you don't need anything. I think put designated beneficiary on there. Like, for you, Paul, if it were just starting out, it would be, just put your probably a beneficiary, your siblings. You could put your parents, but likely you'd want to make it go down a generation, so you might just leave your parents and something simple like that. I don't think you need to go out of your way. I think then if you enter into a situation where now you're married and let's say you have children. Mm-hmm. So now you're still both a young couple, but you're married with children. That's a game changer. Right? So as soon as you have the children, I don't think it's so much the size of the estate that matters. In other words, But by the same token, you might have $1 million life insurance policy. You might have bought your first home. Those two assets alone could put you up there in terms of the value of your estate. But it's probably not driven by that. It's just going to be all my bank accounts, all my investment accounts, my house, whatever I've got. I want to make sure now gets to my minor child or children, as the case may be. So in order for that to happen, a trust really does need to come into play. And so not so much just because I'm trying to avoid probate or reduce my estate taxes, because I may not have that much. But if I die, I don't want some person owning all my stuff. Two things there. One, yes, the will, the basic documents that you mentioned earlier, Paul. You're going to need the will, because the will now becomes one of the most important documents when it's usually not when you're doing your estate planning. But when you have a minor child, you got to appoint a guardian. And that's how you appoint the guardian, through the will.
Right.
So you may want the custody of your child to be held by one person, but I might not want that person in control of my money. So now you take all your other assets and you put them into a revocable trust, would probably be the kind you would be using at this age. A revocable trust, and list a trustee who might be different than your guardian. Make the guardian come to the trustee to get the money to take care of the child. And the language in the trust will be dictating how and when that money comes out, and the trustee will be the one making that distribution. So really a game changer when you have, that. And then if you jump ahead to just either being, let's say you've approached 60, 65, well, now you probably have more assets. You might have grandchildren, but more importantly, you might be thinking about switching from a revocable trust to an irrevocable trust, because I want to do some nursing home planning in addition to estate tax savings bloodline planning, probate avoidance, things like that. So it's really a process. Family dynamics drive what kind of plan you do, all kinds of things.
A lot to consider there. If you have any questions in the estate planning realm, whether it be regarding trusts or some of the more basic documents or anything in the tax realm, also give our studio line a call at 888-205-2263. We'll be taking your questions with Todd Lutsky. Again, that number for our studio line for any of your questions on the estate planning realm with Todd Lutsky, 888-205-2263. We're going to take a quick break here on the Financial Exchange. When we come back, your questions with Todd Lutsky right after this.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
We are back in studio with Todd Lutsky from Cushing & Dolan. If you have any questions about your estate plan or trusts or anything in that realm, give our studio line a call at 888-205-2263. Again, that studio line phone number for any of your questions for Todd Lutsky, 888-205-2263. We're going to hit the phones and kick it to John in Waterbury, Connecticut. You were on with Todd Lutsky.
Hi. Does gifting avoid the 5-year look back in Connecticut?
So, that's a great question because many people confuse these two things. First and foremost, let's describe what the look back is for people who aren't aware of what it is. What I believe you're referring to, John, is the ability to take an asset and for less than fair market value, transfer the asset somewhere where the nursing home can no longer get it. And if you do that, that's called a disqualifying transfer. And yes, you have to stay out of the nursing home for 5 years in order for us to sort of cleanse that transfer and make the asset protected. Another question you asked is, does that 5-year rule apply to Connecticut? In fact, it applies to every state. It's a federal rule, not a state rule. At least there's not a state that I'm aware of that does not do it. Medicaid is a federal statute implemented by each state. So, yes, the 5-year rule applies to you. Now people know what the 5-year rule is. But I also want to take it one step further because sometimes people confuse this with the estate tax gifting rules. And I know you might not have asked about that, John, but I can't help but just educate people on it. Some people think that, well, if I just gift it away to my children, then I don't have a 5-year waiting period. But if I gift it to a trust, then I do have a 5-year waiting period. No, the 5-year waiting period applies to any kind of a transfer to anybody or a trust if it's for less than fair market value in exchange. So you can't avoid that. Number two, some people will say, oh, wait a minute, I heard that I can give away $19,000 per year per person to anybody I want, and I don't have to pay a gift tax. So if I do that, I just will avoid my 5-year waiting period as well. Mutually exclusive rules here, folks. There's a difference between Medicaid rules and IRS rules. For Medicaid purposes, you give away $1 and you have a 5-year waiting period. For IRS purposes, you're allowed to give away $19,000 and not file a gift tax return at all and not pay. You don't have to report. You don't have to file. It's just a freebie. 2 separate rules, mutually exclusive. So, folks, hope that helps a little bit in that example. But by the same token, one of the things that you can do when you're getting your estate plan together is get this guide, because folks like John that maybe are thinking about doing an estate plan, he wants to protect his assets from the nursing home. This guide, Back to the Basics, will help you kick off your estate plan, gives you questions about what to think about, like what Paul was asking us earlier, age, family dynamics, value, questions to be armed with before you get to your estate planning attorney. Talks all about the basic documents from wills to powers of attorney and explains how, in this case anyway, an irrevocable trust happens to work. 2 of them, I put together a $4 million hypothetical estate plan and then basically give my engagement letter outlining this entire plan. Put your numbers to it, see if this guide will help you do this estate plan for you or in any event, at least help you kick off the estate plan for yourself in one way or another. It's getting close to the end of the month, folks, so get the guide, Back to the Basics, 866-848-5699 or legalexchangeshow.com. You can download it there. Again, 866-848-5699 or legalexchangeshow.com. And for more information, go to our Instagram page, Cushing Dolan.
We're going to go back to the phones here to Sue in Mashpee. Sue, you are on with Todd Lutsky.
Hello, how are you?
Good. How are you?
Lovely weather.
Mm-hmm.
I'm calling up because I'm just trying to decide on a trust. My husband has passed away, and now it's just me.
Mm-hmm.
So I was looking at a few things. I don't like irrevocable because you lose your control. Is that correct?
Yeah, incorrect. So many people think that, so you're not alone. There are many kinds of irrevocable trusts. The kind I think you're thinking about, depending on your net worth, assuming for now you're worth less than, let's say, $4 million. If that's the case, then no. The kind of trust we would probably be thinking about for you, you actually would end up keeping about 98% control. That's what I like to tell you. But when I'm done explaining it in detail, you'd be amazed and you'd say, wow, I don't feel like I gave up any. Again, different rules for different people and different levels of net worth. So you're right. There are irrevocable trusts out there that you do lose control over and that you are more rigid. But there's also kinds that are drafted that aren't like that.
So what would be the minimum amount for this particular one that you're saying $4 million? Would it be $2 million?
No. I'd say if you have a house and you have some money and you want to protect it for your family, that's up to you. In other words, the size doesn't matter so much. It's just that if you get to a larger level, you probably don't need nursing home planning. But if you're, say you have a $1 million home or a $500,000 home and $500,000 in your investment portfolio, and you want to protect your house, it might be good enough just to protect your house. So hopefully that helps you a little. I think you should probably just reach out to an estate planning elder law lawyer and learn more than we can give you on the radio about how these irrevocable trusts work. I think you'll be amazed. Plus the guide actually has that in there as well.
We're going to go to our third caller here, Charlie in Osterville. You're on with Todd.
Hello, Todd.
Hi.
Over the last couple of years, I've been working on doing a lot of gifting and such to minimize my exposure to Massachusetts estate tax.
Okay.
I heard that there's also a new piece of legislation that if I purchase a property outside of Massachusetts, it's not considered part of my estate calculation for Mass. Is that true?
That's very true. So many people don't think that that's the case, but when you die in Massachusetts, if you're a resident of Mass, then property you own in another state is not taxed in Mass. So if I bought a vacation home down in Florida, but I live in Mass, when I die, that vacation home is not factored into my Mass estate tax. So for example, if my estate is worth $4 million, but the property I bought in Florida is a $2 million home on the beach, well, my estate for Massachusetts is $2 million, not $4 million. So, yeah, you don't have to be giving stuff away, and I don't think you probably should be giving stuff away. And so, does that help?
It does help. One other quick question. What is the decision point that you advise your clients to do a disclaimer on inheritance?
You mean someone died and you're getting the money?
Yeah, but you actually, I think the word is disclaim, or you basically don't accept it.
No. So, but what I'm asking is, I understand what it is. I just want to make sure we're on the same page. So let's say your mom died and your mom left you $2 million and you want to disclaim it. That's what you're saying. So, I think it's all going to be a function of how big your estate is. Remember, you may or may not want it. If your estate's already well over the federal exemption, I guess I don't want to be any wealthier, then maybe I disclaim it. But you got to find out where it goes when you disclaim it. It's not just that easy. You can't direct where it goes. So you'd have to look at their estate plan and say, I disclaim it, but the estate plan then will treat you as if you're dead and leave it accordingly into that estate plan. So be careful, make sure it goes where you want it to go. And again, if your Massachusetts estate is $4 million and you're married and you're getting more than that, I don't know what the number is that you would want to disclaim it, because remember, you might not have a federal estate tax, but you get a step up in basis. It's still your asset. Being a little bit in mass isn't always a huge problem because the rate is lower. So random there on that one in terms of how much. But thanks for the call, and I hope that helped out a little.
Todd, thanks so much for the time this week. As always, we really appreciate a lot of great information there.
Always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.